Hello and welcome to Williams Mullen's Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Brydon DeWitt, and today I'm pleased to welcome back Matt Anderson to our podcast. Matt is a partner in Williams Mullen's Labor, Employment, and Immigration section. Welcome back, Matt.
Great to be back. It's been a little while.
So, Matt, you recently authored a legal alert that really caught my eye, and I thought I have to have Matt come on to the Benefits Companion. Your alert was entitled Sick Leave for All. It detailed a proposed Virginia House bill which would significantly expand paid sick leave rights for employees across the Commonwealth. While the bill is still in the proposed stage, it's a topic that could have far-reaching implications for many of our listeners. But before we dive into House Bill 5, Matt, can you give us a brief history of Virginia's current paid sick leave law and how we got to this point?
Well, most people probably don't realize that Virginia actually does have a paid sick leave statute. That's because it only applies to a very narrow slice of the Virginia workforce, which are what the statute calls home health workers, which you think of people who are hired to come into someone's home to provide them medical care. I think, your elderly, maybe those with disabilities, those type of workers. And they get certain amount of paid sick leave if they work a certain amount of hours. Or that law went into effect in 2021. So there has been a paid sick leave statute on the books in Virginia here for about 5 years. But it's, like I said, it's very narrow and does not provide leave to many of Virginia's workers.
So I take it that this proposal in the General Assembly then would just take this idea and greatly expand it. How far is the expansion? Who will have to give paid sick leave under this proposed legislation, and who will be eligible to use it?
So actually, the General Assembly tried to expand paid sick leave last term. The bill passed in both the House and the Senate side, but was ultimately vetoed by Governor Youngkin. So with the results of this past November's election, the Democrats again put this House Bill 5 back onto the docket to try and essentially redo what they had done last year, but with a more friendly governor who's less likely to veto, which we can get into later. But the proposal is that every employee in Virginia, whether that's full-time, part-time, temporary, if you are an employee, someone who is working for an employer for remuneration, you will get 1 hour of paid sick leave for every 30 hours worked. And you will continue to earn that 1 hour for every 30 hours worked until you get up to 40 hours of paid sick leave. So essentially 1 week of paid sick leave.
And so this week, for, as you said, for any employee.
Any employee, any size employer. So if you have one employee, they are working every 30 hours they work, you got to give them 1 hour of paid sick leave, at least as the bill is currently written.
And is the sick leave at the full hourly rate?
Yes, they are paid at their normal hourly rate. Okay. You don't include things like bonuses or shift differentials or anything like that. It's just at their kind of base hourly rate to the extent they are an hourly employee. And if they're salaried, then you essentially take, what a week's worth of salary is and divide that by 40.
So what can employees use the sick leave for? What qualifies as a qualifying event for sick leave?
So you kind of think of it mostly in terms of kind of what is an FMLA leave. So it would be for care of their own, medical issues, whether that's physical or psychological, a family member, certain family members' health conditions. There's language in there that it's treatment or diagnoses or medical appointments to prevent a medical issue. there's another piece of it that you see in a lot of the similar paid sick leaves from around the country, where you can use paid sick leave to address the fallout from being a victim of domestic violence, sexual assault, or stalking, whether that's the employee or, again, family members. So a lot of times you will see it will be things like receiving treatment for the injuries caused, going to court to get protective orders or testify against the perpetrator. Or taking time off because the victim or the employee's family member who's a victim, they need to move to get away from the domestic abuser, the stalker, the sexual assaulter. So that's kind of the other piece where it's not necessarily a medical condition, but employees would be able to use their paid sick leave to receive pay while dealing with kind of the results of being a victim of these crimes.
So it sounds like it's up to 40 hours of paid FMLA leave, what employers would understand as FMLA leave, and then potentially these additional types of leave would be added to the bill.
Yes, I think that's a great way to think of it.
And so if an employer thinks, well, we're okay, we have short-term disability benefits, we have a paid sick leave policy, it might not pass muster once this legislation is passed. It sounds like you'd have to really review all of your policies. Or if you had a short-term disability policy that covered 70% of your wages, that wouldn't work because you're saying it's 100%.
Right.
Yeah.
Right. And so, yeah, then the bill does have language in it that says, if you, employer, have a paid leave policy that can be used for these things that, and is at least as generous as this law, you don't need to create a second paid leave policy to supplement what you have. So, if you're an employer and you have a paid time off policy and it's, hey, on January 1, everyone gets 45 hours of paid time off that can be used for any reason whatsoever, sick, vacation, going to your kids' school conferences. We don't ask questions. You just have to follow these procedures to access that leave, as far as, when you can provide notice. And if it's a situation where you can't, here's the contingency on providing it as soon as possible. If you had a policy like that, theoretically that could comply with this law and you wouldn't need to create a new policy.
Well, that could be good news for employers. So what I'm hearing is if you have a vacation policy, you allow a week, 2 weeks of vacation, an employee who uses that to go to uh, the Dominican Republic would eat up their paid sick leave potentially. The employer wouldn't have to create an additional 40 hours of sick leave if they had a very kind of open-ended paid time off policy.
That's generally correct. But again, it's hard to make these broad sweeping statements when you don't have the actual plan in front of you. And so, I often, when I'm working with employers on their different policies, particularly multi-state employers who have employees in states that already have these laws on the books, for example, in a handbook review, we are often going into, their Maryland, the state handbook addendum, because Maryland's a nearby state that has essentially a very similar paid sick leave scheme. I believe they call it paid sick and safe leave because it covers the domestic violence as well. We're often just, going in there instead of dumping the all the language that the Maryland law would require. It's more of, we're tweaking their paid time off policy, or noting, for example, Maryland has a paid sick and safe leave. The company's, paid time off, or whatever they call it, policy serves as a substitute for that. And then you might have language that in there that says company will not retaliate against someone for using leave under the Maryland statute, because some of these statutes require employers to put a kind of non-retaliation language in their policy. So, that could be how an employer who has a paid time off policy could kind of tweak things to comply with this statute.
Right. And I guess we have to remember that we're talking about proposed legislation
Right.
right now. So listeners, at this point, and we're recording this in December of 2025, this has not been passed and signed into law yet. So there could be changes with the proposed legislation. With that said, do you anticipate this passing? Are we, in a couple of months, are we going to be saying, all right, this is the law now?
I would not be surprised if this passed. Like I said, the General Assembly passed a similar bill last year, and it was vetoed by Governor Youngkin. I would imagine Governor-elect Spanberger is more sympathetic to this kind of bill, and so I would imagine between that, the fact that last year in the General Assembly it was a razor thin Democratic majority. This is a much more robust Democratic majority in the General Assembly this year. So I don't see any reason why this would not pass in some form. My guess, though, is that it does get modified, mainly because right now it is all employers, all employees. That is, if you think big, an employer like Amazon, having paid sick leave in Virginia is a drop in their bucket. They're doing this in plenty of other states. Their home state of Washington was one of the first states to have a paid sick leave, so they're used to it. It's probably nothing for them. But if you think of a manufacturing facility where they're running 24/7, they've got 3 shifts coming in. If someone is using paid sick leave, they're getting paid the hours that they're not working, and the manufacturing facility has to also pay the person that replaces them on whatever machine. So it's essentially double billed for that time. Or if you think of a mom and pop shop that has 5 employees and is barely breaking even, what kind of economic impact does having to pay someone paid sick leave have to do? And for a lot of these laws, some states have scales where it's like, if you have over a certain threshold of employees, then you have to pay 100% of wages. If you have this range, then you have to pay 60%. Some states I've even seen they have, if we have sick and safe leave, and if you have over a certain amount of employees, it's paid. If you have under that threshold, then you just have to give them the leave. It does not have to be paid. It'll be interesting to see what tweaks, if any, are made, but I would imagine that there's going to be some sort of threshold, whether it's employer size, whether it's kind of like the FMLA, where it's like you have to work a certain number of hours, be employed for a year and work a certain number of hours for the employer to become eligible. We'll see.
Yeah, I hope there's some relief in that area, because it's the smaller, mid-sized to smaller employers that don't have the finances to handle things like this, nor the running their business. They may not even be aware of these types of requirements. And I think of that with all the complexities of employee benefit laws, that those employers are subject to them, but they just don't have the capacity to even be aware or to comply. So I hope there's some relief for the smaller businesses. So Matt, once again, thank you for joining us on the Benefits Companion. Thanks for coming back. And that will wrap up our conversation. If listeners have any questions or suggestions for future episodes of this podcast, please contact me. You can also visit our employee benefits page at williamsmullen.com/employee benefits. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Finally, be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.
This podcast contains general condensed summaries of actual legal matters, statutes, and opinions for information purposes. It is not meant to be and should not be construed as legal advice. Individuals with particular needs on specific issues should retain our services or the services of other competent counsel.